Pawan Arora ji. Mr. Pawan Arora ji is the co-chairman of our Audit Tax Committee of the PhD Chamber of Commerce. He is a member of Institute of Chartered Accountants of India and a law graduate. Now he is working as a director in the Athena Law House and the head of the GST Advisory Committee. Shri Pawan Arora ji, please come to our starters presentation.
Good afternoon, everyone. So now I think good morning shifted to good afternoon, and our delicious lunch is waiting for us also. So I will not take much time. First of all, I want to thank Vimal sir and the PhD committee to elect me as a co-chairman of the Indirect Tax Committee. So my topic, next slide. So my topic of discussion is the cross empowerment of the central and state officers, and whether if the one department has completed the proceedings, then whether other department can initiate the same, and what are the legal judicial pronouncements are available with us on this respect. So if you remember, there was a discussion on bringing the one GST in the country, the common for the state and center, but somehow there is no consensus of the states and center for this single GST. So ultimately we come up with the two laws of GST, and in fact IGST is also there. So there are 3 acts, and as we know that every act give the powers to their respective officers. So center officers have the power under the central law, the state officer have the power under their state acts, and the central officers have also power to do the assessment under the IGST Act. But now the point has been raised in the GST Council, and that was the discussion was extensively taken in the 9th GST Council minute, that there should be a single interface for the taxpayers, so that they should not feel burden on them to deal with the 2 officers, because in every transaction which is a intra-state transaction, you are supposed to pay CGST as well as SGST. So they said that okay, there should be only single interface for the interaction with the department for all assessments. So now they have agreed in the 9th GST Council minute that okay, we will create a single interface with some guidelines, and there is a next. So there is a detailed discussion under the GST Council minutes. Before that, let's have a look in the 3 sections of the law. First of all, the section 5 of the CGST Act or SGST Act empowers their officers to do their responsibilities and assessments and all these things. And the section 6, which says that if an officer of a state or the center has done assessment, then he will parallelly pass the order under the State or the Center Act. And they say that now you look at carefully the section 6(2)(b). It says, I'm reading it word by word because it is having an importance in this. It says that where a proper officer under the State Goods and Service Tax Act or the UT Act has initiated any proceedings. So please note this word proceeding. I will discuss it later how it is important. On a subject matter. So the subject matter is also an important because it has been discussed in the judicial pronouncements. No proceeding shall be initiated by the proper officer under this act on the same subject matter. So they say if the state officer is doing or has already initiated any proceedings, then center officer will not initiate the proceedings on the same subject matter. And it also provides that if proceedings has already been started, then the entire proceedings and appeals will be done under the same statute. Now there is in the IGST Act also there is a requirement to empower the state officer. So section 4 of the IGST Act empowers the state officer to do the assessments under the IGST Act. Now let's come to the important discussion of the GST Council. In the 9th GST Council, they, as I told, that they have suggested to have a single interface. And there is a detailed discussion on the constitutional hurdle of giving the power to the state officer for the assessment under the IGST Act. So they said, okay, we will bring some solution in this regard so that the state officer will be able to do the assessment of the IGST Act also. And they also say that in case of place of supply, the matter will be resolved, will be taken by the only center, because here in case of dispute in regard to place of supply, 2 states or 3 states may be involved. So there could be a dispute among the states that who will do the assessment. So they say, okay, in respect to place of supply, only center will do the assessment. And further, they have deliberated on a point that in respect to the assessments on which a specific state request to center to the assessment, then in that case also center will do the assessments and not the states. And there is one interesting point come out from the council minutes, that intelligence based information, mark this word, intelligence based enforcement actions, they have created a separate category for that, which can be done by the both departments. So that intelligence based enforcement action can be taken by the both jurisdiction, state as well as the center. So what was the conclusion of the 9th GST Council minute, which is given in the para 28? As we discussed, they said, okay, for the assessees having a turnover below 1.5 crore, 90% will be given to the states and 10% will be given to the center. And the assessees who are over and above 1.5 crore turnover, the 50% will be given to the state and 50% will be given to the center. Now, 2 points arises that how this turnover will be computed. So criteria is given in the guidelines of the GST Council, which is given there in their circular. And the distribution of the assessees will be done by the computer on the sampling basis. So this is not a manual assignment, and even the assessee cannot go for request for assigning either center or the state. This will be done by the computer through a sampling. Now, although I don't know if you or anyone faced this, in the 6th point, if you see, they say that the jurisdiction can be transferred based on the GST Council guidelines. So I don't know कि अभी तक किसी का transfer हुआ है कि नहीं हुआ है, but they have kept the scope of changing the jurisdiction also. And in the para 8 point, as I discussed, they have created a separate category for the enforcement based actions which can be taken by the both. Now in point 9, they have said that, okay, in the IGST Act, the cross empowerment, they will bring some amendment so that the state officer can do the assessments, and as the section 4 has given the power for this, and they have created an exception for the disputes related to the place of supply. So followed by this GST Council minutes, the GST Council has issued the circular in this regard, in which they have created a guidelines, which is the repetitive of the all these things which they have decided. Now, if you see, interestingly, in the GST Council, one minister of Assam has pointed out that this turnover may create a confusion or the fight among the states and center in future, that how this will be decided if somebody is crossing the 1.5 crore turnover. So I don't know how it will happen in the practically, that at the back end, if somebody is crossing the 1.5 crore turnover, then with how their jurisdiction is changed by the computer. Now question arises that can we check who is our administrative office? So they called both office as jurisdiction office, but to whom you are assigned, that is either state or center, they are called as administrative office. So how you can check that who is your administrative office? You can go on the GSTN portal, and there is a functionality on this search taxpayer. And if you put your GSTN there, so you will get the details where the administrative office details is given there. So in this case, like their center is their administrative office. So in this way, you can check that who is your administrative office. Now coming to the interesting dispute which has arisen in this GST Council meeting conclusion, that intelligence based information. Now you will ask, what is this intelligence based information? I think this is not discussed in the, I think अब जितनी judgments मैंने पढ़ी है, मेरे को अभी उसमें कहीं conclusion नहीं मिला, ना ही law में, ना ही कोई GST Council minute के discussion में आया कि what is this intelligence based information. But yes, there is a circular of the CBIC which says in case of intelligence based information, if any officer initiate the proceedings, then he will only conclude the entire chain and he will not transfer the case to the different jurisdiction. So if center has initiated the enforcement based action, then he will conclude the same and he will not transfer the matter to the state officers. Nowadays, you have seen that, as sir said, that in every case they are issuing the summon. Why they are issuing the summon? This is one of the reason. If you find in the summon, they say that we are in the possession of some information and some intelligence has come to us. So there could be a reason for this, that they are trying to exercise this broad power which is not yet concluded by any court, that what be the meaning of the intelligence based information. So this could be a future point of litigation, that how an officer will decide that whether a information is whether a proceedings is intelligence based or non-intelligence based. I will give you an example. This last week itself I have handled this. If you see that in the annual return, you submit the input tax credit, the total input tax credit. As far as rule under 42 is concerned, you only reverse the credit based on the common inputs, but there is no column in the annual return which capture the common credit. So you only put 100% credit in the returns, but you reverse the credit under rule 42 based on the common credit. Now, the officer has not issued me notice, has not me asked any clarification. He just simply put a summon that to my information, you have not reversed the credit of 10 lakh only. So the question is of only 10 lakh. You have not, less reversed the credit of 10 lakh under rule 42. So you please come present before me. So we have given a written reply to him that we have common credit this much and we have reversed the credit on the common, and in the base which you have taken is the only the total credit. How he has behaved, he said, why you come after lunch to me? You have been asked to appear at 11 o'clock. Next time you come at 11. Okay, the client asked me to come, sir, please come with me because he is seems to be very dangerous. I went. At 11 o'clock, he said, okay, wait. At 1 p.m., he's called inside the cabin, and in 5 minutes, he just put 5 queries more to us and said, okay, agli baar aana. When we replied to those queries, he said, आप अगली बार मैंने उससे फोन करके पूछा कि सर टाइम बता दो, बोले 11 बजे आना, और फिर 11 बजे 1 बजे तक वेट करा के कहता है मुझे कुछ अर्जेंट काम है, मैं आप आज को डील नहीं कर पाऊंगा. सो दिस इज लाइक कुछ भी इंफॉर्मेशन सम्मन इश्यू करा, इंटेलिजेंस बेस्ड बनाया और आपको बुला लिया. सो यहां पर कोर्ट्स भी रिलीफ नहीं दे रही हैं. अभी हम जजमेंट डिस्कस करेंगे दैट दिस इंटेलिजेंस बेस्ड इंफॉर्मेशन कैन बी इनिशिएटेड बाय एनी ऑफ द ऑफिसर्स, एंड एज फार एज सम्मन इज कंसर्न वी विल सी दैट हाउ द सम्मन हैज बीन क्रिएटेड अनदर alternative for the tax officers to initiate inquiry against you. So under section 6, there is a point that the government can create a condition for the cross empowerment. Now for the cross empowerment, the DGGI has raised a question before the CBIC that whether to do the intelligence based actions, we need any notification from the center or the state. So they have clarified no. Section 6 itself gives you the power to investigate the intelligence based enforcement action against the persons who have been assigned to the states also, and there is no separate notification required. Now, cross empowerment of the refund matters. So as I discussed that section 6 gives the power, and it also say that subject to the condition. So as far as section 54 and 55, which is a refund sections, the center has given the power with a condition that refund of exports will not be handled by the states. The refund of exports of IGST will be given only by the centers. So the jurisdiction over the export is with the center only. Apart from that, other exports are other refunds with the both center and the state, and your assigned administrative office will handle that refund matter. So this is regarding the things available in the statutes and the discussions and the background of this. Now coming to the legal pronouncement on this issue. See this, can anyone tell me what this picture is telling to us? Because this picture has been created by my team after reading all the judgments, which I am going to discuss. So this picture is telling कि भैया एक तरफ कुआं एक तरफ खाई है, ठीक है, और गिरना है आपको किसी एक में, लेकिन उसके बाद कुएं में जो रस्सी है वो बचाने के लिए नहीं है, वो इसलिए है क्योंकि जब कुएं में गिरोगे तो रस्सी से खींच के खाई में भी लेके जा सकते हैं आपको. And court has permitted to do so. The court had permitted to do so because of the interesting interpretation of the section 67, section 70 and all these things. So this will happen in future also, and because there is a both type of judgment in favor and the against of the assessees. Now coming to the first judgment, again as Gitika said, Gujarat High Court. So Gujarat High Court is very kind to the assessees. I have seen in last many years. And in every presentation, you found the Gujarat High Court judgment in favor of the assessee. So if you have any issue, you must first approach the court only. So in this, what happened that search was conducted under section 67. So please note the section also carefully. Under section 67, the search can be conducted. So DGGI, which is a center office, has conducted the search of the assessee. Now someone has been issued under section 70 by the Commissioner of the State Tax. So section 70 allows the officers to summon to produce the evidence or to give the evidence in respect to any inquiry. And again, first DGGI Ahmedabad, now again another department of the center has issued the summon under section 70, which is a DGGI Surat. Now 3 parallel proceedings has been started against this assessee. So now Honorable Gujarat High Court has given the relief to this assessee. They said the first, who is a DGGI Ahmedabad, has initiated the search, can only conduct these proceedings, and the remaining 2 departments, which is a Deputy Commissioner of State Tax and the DGGI Surat, who has issued the summon, cannot do the cannot do the assessments of this the assessee, and they allowed the relief to the assessee. There are other favorable judgments. This is Raj Metal Industries, who's in Calcutta High Court. In this case also, there are 2 parallel investigation both by the state and center. So in this case, West Bengal authorities has issued the summon, and the state has also issued the summon in this case. So by taking the course of section 62B, the Calcutta High Court has allowed the relief to the assessee and set aside or asked to drop the proceedings of the summons which has been issued later. Now the judgment of this Suresh Bhai, in this case again The search was conducted by the state authorities and the state center authorities parallelly. Now, in this case, only interim relief is given. As far as coercive action is concerned, they said, okay, you will not take any coercive action against this assessee because there is a two parallel proceedings are going on. Now, I told you that mark two words under section 6(2)(b), which is a proceeding and subject matter. So now there is a two very interesting judgment. I recommend all of you to read it word by word also. The first judgment is of Allahabad High Court in case of GK Trading, and the other one is Kupan of the Madras High Court. Now, in these cases, one proceeding is going on under section 67, which is a search, and the parallel proceedings have been initiated by the department by issuing the summon under section 70. Now, the court said, just read it carefully. Section 6(2)(b) says, where any proceedings initiated by one on the same subject matter, then the other cannot initiate the same. And the section 70 allows that where for any inquiry, they can issue the summon. So they say inquiry and proceedings are two different things. Both cannot be said to be the same. Proceedings followed by inquiry. So in inquiry, they are asking only for the documents. What's the problem to you? You submit the documents. They are asking to you appear before them. What's the problem to you? They are not doing any proceedings. And they further said, okay, if they do any proceeding, then you have an option to come to take a take a reasonable step as per the law. But they have not given the relief for parallel summons. Despite the fact of the Gujarat High Court and other previous two judgments which we have discussed, they said that summon can be issued. It will not be treated as the proceedings initiated by the another officer. So this is the picture will depict that एक तरफ कुआं और एक तरफ खाई है. आपके पास सर्च प्रोसीडिंग्स चल रही हैं, तब भी डिफरेंट जुरिसडिक्शन का डिपार्टमेंट और डिफरेंट जुरिसडिक्शन नहीं, यहां तो सेंटर के ही डिफरेंट डिपार्टमेंट्स मल्टीपल यू आर फेसिंग द समन्स. नाउ अदर इज सब्जेक्ट मैटर. I think sir has also pointed out the subject matter that we are doing the assessment of ITC, not the outward supply, and other is saying that we are doing the assessment of outward supply. And the court said that at the time of initiation of proceedings, subject matter is not final. They are only doing the inquiry. So they started with the section 70 assessment or summon. They are doing the inquiry. And they will turn into a different point. So there is a difference in the subject matter, and they have quoted one judgment of the Honorable Supreme Court in which the Honorable Supreme Court has dealt with the word subject matter. So these two judgments are very dangerous for the assessees because they have allowed multiple summons by the multiple authorities, despite the fact that the council, the lawmakers, have a clear intent to have a single interface for the taxpayers. So this is happening. And मैं अभी सब सुन रहा था sessions. The ground earlier when the GST has been introduced, there is a two law. One is GST law and other is the portal law, GST and portal law. Now there is a third law, ground reality, is altogether different. So this is happening nowadays. So be careful about these two judgments which officers nowadays issuing. Up practically speaking, what I do, as Gitika said, never hurt the ego of any officer, but politely submit a letter to that officer that okay, my proceedings are already going on, you may please kindly drop. Agar wo, in some cases it is all depend on officer to officer. In my some cases they have dropped it. They said okay, but in some cases they said boss अभी खाली बुलाया है, आपके यहाँ आ जाए, कोई बात नहीं, आपके पास डॉक्यूमेंट नहीं है मत आओ, हम आपके यहाँ आ जाते हैं. So everything is happening. Now coming to the other cases which are against the SSCs, in this Kaushal Kumar Mishra, the fact was that the two state center department, DGGI Kanpur and DGGI Ludhiana and three DGGI Bhopal, all three has issued the summon. So all three are the central department. All three have issued the summon, and court said nothing is wrong in this because this is not of covering under section 62B because it's not a proceedings. It is only an inquiry. So you have to follow up. You have to handle all these three. Now in the Siddhi Vinayak also, summon has been issued under section 70 by the center and show cause notice has been issued by the state under section 74. So they said both are not the same. You have to handle the summon also because it is mere inquiry. Now there is a sign of relief in this judgment of Miss MS Mridul, where the two central officers have initiated the proceedings. I think three or more than 10 searches has happened. Gautam Budh Commissionerate has first initiated the proceedings, and then DGGI Kanpur, DGGI Delhi, DGGI Ghaziabad, DGGI Ahmedabad. So these five authorities have initiated the proceedings. In this, the Honorable Delhi High Court has said that only Gautam Budh Commissionerate will take up the matter, and all other authorities will hand over to the Gautam Budh Commissionerate and will not interface with the SSC. मेरे को एक एग्जांपल याद आ गया, हम कोर्ट्स की बात करते हैं इसमें रिलीफ की. In my one case, I think 5 years back, the audit has been initiated by CAG of the private party. So we went to Delhi High Court, and Delhi High Court say, okay, CAG cannot do the audit of the private party, so kindly you can't do the audit. But at the last say they are only asking for the document. What's the problem with you? You just give the documents and matter ends. We said, okay, we are ready to give the documents. And then the client has not further communicated with us after this judgment. After 1 month, I asked, sir, आपको तंग तो नहीं किया उन्होंने उसके बाद? डॉक्यूमेंट आपने दे दिए थे? वो बोले उन्होंने डॉक्यूमेंट की इतनी लंबी लिस्ट दी थी हमें कि वो हाई कोर्ट का जजमेंट तो डॉक्यूमेंट्स देना है, बट उनको डॉक्यूमेंट्स का अंत ही नहीं हो रहा था. सो दिस इज हैपनिंग एज अ ग्राउंड रियलिटी. So this is a public forum. So now in the SSM exports also, the 3 center department has initiated the proceedings, and this relying on the all previous judgment, the Honorable Delhi High Court has given the relief. Now coming to one more interesting judgment of RCI Industries. This is again an interesting judgment. In this case, Delhi GST department, first DGGI Gurugram has initiated the proceedings, and they have also issued the show cause notice. Now Delhi GST department has also started doing the investigation and issued the summon for the same period which the DGGI Gurugram has covered. Later on, they have restricted their period to only 1 year, which has not been covered by the DGGI Gurugram show cause notice. So the Honorable Delhi High Court at first, although that was not the point, but they said, first of all, even if the show cause notice is issued by the DGGI, but they are only doing an inquiry, it is not converted into proceedings. If only it converted into proceedings on the same subject matter, then you can take the action as per law. But as of now, they are only doing the inquiry. Secondly, they have pointed out that because the state have restricted their period to the period which has not been covered in the show cause notice, so state can proceed with the investigation proceedings. So this is again one against judgment. So there are both favorable and against judgment, which all depend on the facts of the case, the person who is arguing the case, and the person who is the decision maker of the case. So the conclusion, if we draw from all these things, that the council have the clear intent that they want a single interface for all of the taxpayers. But as I said, there is another law of the ground reality, which is fraudsters के लिए तो होना चाहिए, but जो एक genuine taxpayers हैं, उनके साथ भी ऐसा होता है तो प्रॉब्लम डेफिनेटली होता है. सो आपके जब भी कोई प्रोसीडिंग्स इनिशिएट हो, first you I think you all know that who are administrative office. So first check whether the proceedings have been initiated by the administrative office or the other person, and you can I will discuss that how you can request them that you are not the jurisdictional officer or you are not the administrative office, so kindly drop these proceedings. And if parallel proceedings are going on, then at least, okay, whether you want to go to the court or not, but at least you must write to the departments for dropping the parallel proceedings, because in the courtroom all these written documents will come as in support to you. Your verbal submissions, your verbal request will not play any role in your case. So all these request letters for dropping the parallel proceedings should be in writing. Now coming to the next slide, although this was as a draft notification, it not notified, this has been put up in the 22nd GST Council meeting, but we can discuss on it in the type of assessment. So if we discuss that provisional assessment which has to be done under section 60, that has to be done only by the administrative office who has been assigned to you. That is either state or the center who has been assigned to you. The scrutiny of the returns, section 61, under which GST ASMT 10 issued by the department, that has also to be done by only administrative office. The other is scrutiny of assessment of non-filers of returns, that is also done by the administrative office. Now coming to the assessment of the unregistered person. So there could be a play of enforcement based action also, intelligence based enforcement action, because person is unregistered. So that can be very easily said to be intelligence based in assessment. And secondly, because the person is unregistered, computer have no option to allocate the assessee because he doesn't have any turnover with him prior to the investigation. So both department can do the assessment. So who will first initiate will handle your assessment of the unregistered person. Summary assessments in certain special cases, that has to be done by administrative office. Audit by the authorities, that has also be done by the administrative office. So practically I have handled the case where the administrative office has not the issue, the audit other department has issued. So we have simply put up a request letter and they have then dropped that notice of the audit because they were not the administrative office. Special audit, again administrative office. Now power of inspection, search and seizure. So this is cross empowerment allowed. I think in the notification they have put it some condition, but that is not in the only draft mode. So that condition is not applicable. Again, inspection of goods. No, I think inspection of goods during the transit. Sorry, ये गलत है. Administrative office नहीं. Whosoever will catch you has to do the assessment on the way. Power to arrest. Again, this is not the administrative office. Whosoever doing is your proceedings have the power to arrest. So it's a part and parcel of the proceedings. So power to arrest is a part and parcel of the proceedings. So the officer who is doing the assessment can arrest the person. Power to summon the person under section 70. We have already discussed that this is only an inquiry. So anyone can issue the summon to you. And access to business premises, because it can be said to be intelligence based. So anyone can do this. And proceedings arising out of the chapter 10, 20, this is transitional provision related. So that is again cross empowerment is allowed. In the draft notification of the IGST, these 4 exceptions has been created as far as power to state is concerned. They said that any disputed required determination of place of supply is only with the center. When one state involved in the interstate transaction requests the case to be adjudicated by the officer appointed under section 3 of the IGST Act. So let's say if the goods are moving from Delhi to Bombay and Bombay officer wants that, I don't want to get it adjudicated by the Delhi officer, but by the center officer. So he can request and that assessment will be done by the center officer only. Refund of IGST export, that notification is already in place, and any other purpose that is recommended by the council. So I think with that, I end up my session. Thank you.
Thank you, sir, Pawan sir, for your valuable